So the final topic that we need to cover is one of court procedure. It deals with how court cases take place, what's going on behind them, and what are the principles involved around some of the major elements of court procedure. So let's get into it. So Australian courts and the Australian system operates as an adversarial system. Now, we discussed that as one of the first lectures in this series when we were talking about different countries' approach to legal systems. The different countries have different approaches. We can have a common law system like we do in Australia, or in many, say, European countries, continental European countries, we have a civil law system. A civil law system being based upon Roman and the Napoleonic Code, Roman law and the Napoleonic Code, a code-based approach versus a judge-based approach. Now, these operate quite differently. So in the common law system, we have this adversarial system. What does that mean? It means that the parties are actually competing. So within rules of procedure and evidence, so there are some ways we need to conduct the case, but within these rules, each of the parties conduct their own case. The judge is an impartial referee. They observe and listen, ensure the rules are followed, but they don't actually do any investigating, right? No investigating. They don't follow lines of inquiry, etc., or they shouldn't be doing that. It's up to the parties to argue their particular case, their point of view, and for the judge to be like a referee. Now, that's quite different to the civil law system, where the judge is often like an investigator trying to get to the truth. Okay, so we have these two parties arguing against each other. In a criminal trial, it's the Crown as the representative of society arguing against the defendant. In a civil trial, we're dealing with a plaintiff arguing against a defendant. As we've just mentioned, this adversarial system is quite different to the inquisitorial system used in civil law countries. Okay? Whereas the adversarial system is a contest between the parties, the inquisitorial system is an inquiry into the truth, where the judge is a government official rather than someone appointed from the lawyers. They're an active participant in all of the proceedings and trying to get to the heart of the matter. So if we look at a case in Australia, we'll see that a lot of people are involved. We have the judges, who are the referees, for want of a better term. We can have juries if it's a trial that requires a jury, maybe an important criminal matter. They will be just ordinary people who are deciding questions of fact. We already know that, and the judges will be deciding questions of law and procedure. There'll be lawyers involved, barristers, they're the actual people who speak in court. The solicitors, they kind of prepare the case, and they do what's called, they brief the barrister. Okay, so the solicitors work with the barristers, but the barristers are the people speaking in court. The solicitors are helping the barristers. And there's also a lot of other personnel, people to help the judge's associate, someone to record what's going on, the court reporter. That's important, right? The court reporter, particularly important next week when we look at the doctrine of precedent, because we need a good record of the court case if the doctrine of precedent is going to operate. So there's a lot of people involved in a court procedure, and that's one of the reasons why it's so expensive. Let's just take a hypothetical situation where Johnny wants to sue Kate to get maybe there's an unpaid debt involved. So litigating, right, or suing someone is only one particular action someone might take. Next week, we'll look at a couple of alternative dispute resolution mechanisms, right? So ADR. We'll look at them next week. There are alternative dispute resolutions that you might use to get this debt back, because litigation can be a very costly, expensive, and stressful at times process to actually go through. So it's not the only option, but we're going to look as though it's the option that Johnny might choose. So if Johnny decides to sue Kate, it's going to be a civil action. It's not criminal. He just wants to get the money back that he's owed. Johnny will be the plaintiff and he will have the burden of proof. So Johnny has to prove that Kate owes him the money. The standard of proof will be the balance of probabilities. So he just has to show it's more likely than not that Kate owes him the money. Now, if it were a criminal matter, then the Crown, right, would be the prosecutor. They would have the burden of proof and it would be beyond a reasonable doubt. You remember we already covered that kind of material earlier in these videos. Here, what we see is it put into action around this specific example. If Johnny wants to sue Kate to get some money back, then Johnny is going to become the plaintiff. He will have the burden of proof of showing that on the balance of probabilities, Kate owes the money. So the onus or the burden of proof is on the person who's trying to prove their case, the person bringing the case, right, who's trying to establish that they've been wronged. The standard of proof is the level of proof. It's either the balance of probabilities, as we said, more likely than not, for a civil case, or beyond a reasonable doubt, right? Virtually certain if it's a criminal case. So the judge is kind of sitting there as the referee and they make the decision. They don't do any investigating, they're deciding between the two arguments that are put before them. Or sometimes if we do have a jury, then the jury is deciding questions of fact and the judge is deciding questions of law. If there's only a judge, the judge has to decide both, okay? So they make a decision about law and fact as to what happens, and the decision rolls from there. The judge will then decide whether Johnny should get his money or not. If Johnny or Kate, but if Johnny isn't satisfied with the outcome or decision, then he can appeal it to a higher court in the court hierarchy, which is why we went through all of that stuff about the court hierarchy, because Johnny has a right to get that decision looked at, particularly if the judge particularly if the judge has done something wrong. If Johnny decides to appeal, then he becomes the appellant and the other party is the respondent. Note the terminology changes. At first instance, the first time it goes to trial, we have a plaintiff and a defendant. At an appeal, we have an appellant and a respondent. Well, that's a big section of content that we've gone through. Now, I know that many of you will be across most or maybe even all of that content, and for several others, there's a lot that you won't know. Try and concentrate on the core elements and see how they all link together. What we're also going to be doing is coming back to some of these concepts as we go through the rest of the course. These are foundational elements that we need if we're going to understand how the law works and how we apply the law as we go through the rest of the course. So I know it's been a lot of content. Thanks for sticking through it, and hopefully you can get to see the benefit of going through this as we go further down and deeper into the legal elements of the course.